Hello and welcome to yet another episode of the In-News series. Today we are going to discuss a very controversial topic. If a woman has been given dowry by her parents at the time of marriage, does her right to inherit property cease? Here we are talking about the property that she would inherit from her parents. The Goa bench of the Bombay High Court has something to say over this. From that perspective, we are going to discuss many things. So these are the many topics that we are going to discuss step by step. The case's name will also be mentioned. A daughter's right to family property will not extinguish even if dowry was provided to her at the time of marriage. As controversial as it may sound, the concept of dowry originated from the fact that from the practice that a woman does not have enough right to inherit at the old, if we go back to ancient times, and if she is not educated enough, a monetary compensation was given to the groom's family along the bride at the time of marriage. This case was Teresina Martins David versus Miguel Cuarta, Rosario Martins and others. Justice M.S. Sona quashed a deed transferring the petitioner's daughter's property to her brothers without her consent. We will delve into the case. The case revolved around a petition which was filed by the eldest daughter in a family of 10 people, 4 brothers, 4 sisters, 1 mother, 1 father. In her plea, the petitioner drew attention to a deed of succession which was executed in her favor by her late father, Antonio Martins, declaring her as the property heir. And the plea also contested the transfer for deed which was dated September 8, 1990, by way of which her brother and mother had transferred the petitioner's family shop. So, the mother of the petitioner and the brother, they transferred the family shop to their 2 other brothers, seeking to declare the same as null and void. The daughter also prayed for a permanent injunction or stoppage restraining her brothers from transferring her property without her written consent. Okay, moving ahead. Now, the petitioner's brother said that sufficient dowry was provided at the time of her marriage, and that is why she doesn't have any right to property right now. The sweet shop and the property beneath it were brought into the partnership. We are talking about the shop that was transferred, brought into the partnership and was an asset of the firm, they contended, as well as based on this, they argued that neither the petitioner nor her 3 sisters had any right, title or interest in the suit shop. Petitioner's claim will be barred by the statute of limitation as more than the stipulated 3 years had passed. This was their contest, that more than 3 years has passed since the knowledge of this particular transfer deed, and that is why it shouldn't be considered by the court. Petitioner filed her suit after 4 years of time. The dowry system in India, it basically refers to the bride's family giving certain gifts and household items to the bridegroom, his parents or his relatives as a condition of the marriage. That means if you give these gifts, then only we will come and marry your daughter. Nature, it could be payment in cash or some kind of gifts given to the bridegroom's family, although dowry is prohibited through Dowry Prohibition Act of 1961. Dowry, according to this act, has been defined as any property or valuable security which is given or agreed to be given either directly or indirectly by one party to a marriage to other party to the marriage, or by the parent of either party to a marriage, or by any other person. Any other person is also given to either party of the marriage, or to any other person at or before at any time after the marriage. Now, Dowry Prohibition Act of 1961 prohibits giving or taking of dowry, both the things. Imprisonment is there for a term of not less than 5 years. Fine will be there of not less than rupees 15,000 or an amount of the value of such dowry, whichever is more. Then section 304B of the IPC talks about dowry death of a woman who was subjected to cruelty or any sort of torture by her husband or any relative or any relative of the husband. Section 498 of the IPC talks about offence of cruelty against the husband or his relative if the wife commits suicide within a period of 7 years from the date of her marriage because of the incessant demand for dowry. Section 174 of the CRPC was also amended to secure post-mortem in case of suicide or death of a woman within 7 years of her marriage. Section 113A has been introduced in the Evidence Act of 1872, raising a presumption of cruelty as defined under this section. Now, the current case, the trial court, by a judgment and decree dated May 31st, 2003. So, we are going back. It dismissed the daughter's suit that she has the right to inherit. Partly decreed the counterclaim by cancelling her deed of succession. However, the first appellate court upheld the dismissal of the daughter's suit, set aside the decree in the counterclaim, and upheld the succession deed showing her as the one of the successor of the late Antonio Martins. And the daughter instituted a second appeal before the Goa bench of the Bombay High Court, questioning the dismissal of her suit because she was made the property heir. Her brothers didn't question the rejection of their counterclaim or the previous declaration of a succession deed as valid. Moving ahead. Although the present suit was filed by the petitioner after 4 years of instituting the transfer deed that the court has observed, the daughter came to know about it only 6 weeks prior to the institution of the suit, and that is why this was considered by the court. The limitation period in this case was governed by the provisions of the Article 59 of the Schedule to the Limitation Act of 1963. Now, for a suit to cancel or set aside an instrument or a decree, or for the rescission of a contract, the period of limitation prescribed is 3 years. The suit was filed within 4 years. The time for which this period begins to run is when the fact entitling plaintiff to have the instrument, that means if I am the plaintiff, I must have a certain, the knowledge should be given in a certain period of time, then only I will institute a suit. So, the plaintiff to have the instrument or decree cancelled or set aside for the contract rescinded first became known to him. Okay, that is why this was considered. The court also drew attention to the lack of evidence which was presented by the brothers that she gained knowledge before she says so, deeming that this was an essential requirement as per the law laid down in the SC's 1961 ruling of the K.S. Nanji and Company versus Jata Shankar Dosa and others. Portuguese Civil Code was also considered of 1867, such as Article These Many. Moving ahead, Article 1565 of the Code says that the parents or grandparents, we are talking about the Portuguese Code, grandparents or parents shall not be entitled to sell or mortgage to children or grandchildren if the other children or grandchildren do not have the consent to it. Denying the defendant's contention that Article 1565 of the Portuguese Civil Code was repealed by extension of the Transfer of the Properties Act of 1881 to Goa. This was said by the brothers. The court reiterated its 2011 decision of this case, saying that it is clear that the provisions of the Article 1565 of the Code are still in practice. Therefore, Matilda, who is the mother of the plaintiff, she was not entitled to transfer her share in the suit shop to her two sons without the consent of the other sons and daughters. In 2012, through the Pemavati Basu Naik and others versus Suresh Basu Naik and another, the Bombay High Court says that there is an express bar under which the parents cannot sell the immovable property to the children without the consent of all the children. So that is why, moving ahead, Article 2177 of the Code says that the co-owner may not, however, dispose of any specific part of the common property unless the same is allotted to him in partition. The transfer of the rights which he has to share which belongs to him may be restricted in terms of law. 1999 ruling in Jose Antonio Felipe Pascual da Piedad Carlos dos Milagres Miranda versus Joao Luis Lorante dos Milagres Miranda. This was said in this particular case. And an oral partition was not even contemplated under the provisions of the code. The brothers were saying that orally it was partition. What is oral? Nobody has any sort of evidence. In this regard, the other important code was 2184, which provides that the partition of the immobile assets is null if not carried out in the public deed or public proceeding, of course. And it was evident that the play of the partnership property was weak and misconceived attempt to ward off the legal effects of article this and this of the code, and allowed the daughter to appeal in favor of the eldest daughter. So this was all about the case. I hope you understood. Thank you so much for watching.